Hi, I'm Ron Zimmett of the Daytona Beach law firm Zimmett & Quarles. I've been a trial lawyer for over 35 years and risk management consultant to Negley Associates. Welcome to the ongoing series of risk management video tips sponsored by Negley Associates. The topic for this month is violent acts of patients and avoiding liability. Although most people in the mental health field accept the principle that specific acts of violence by a specific patient cannot be predicted with any accuracy, there are still lawsuits holding mental health care providers responsible for not taking appropriate action to protect people from the violent acts of their patients. The courts reason that they only hold providers responsible when the provider does not do what other reasonably prudent mental health care providers would have done under similar circumstances. For example, a court could hold a provider liable for failing to involuntarily detain a patient for an examination as a result of a failure to do a thorough assessment of the patient's risk of being dangerous to a specific person. In fact, many of the cases brought against mental health care providers for patient violent acts include allegations that the assessment of dangerousness was in some way deficient. For example, plaintiffs sometimes contend that the provider was not careful to get information that was readily available from sources such as medical records, the police, or family members. The reasoning is that had the information been obtained, the provider would have taken a different course of action to protect others from the patient's violent acts. To increase the chances that your assessments of violence risk will be thorough and adequate for the circumstances, I highly recommend that you adopt a procedure that's now being referred to in the industry as a structured risk assessment. Basically, this just means that you use a checklist of steps you'll complete to conduct the assessment. For example, one article suggests a 5-step procedure. First, obtain case information from different sources. Second, determine historical and current risk factors. Third, identify past and present protective factors. Fourth, formulate the risk level to decide the intervention. And 5, create a management plan. For a number of years now, researchers have been developing actuarial instruments to help assess the risk of violence. These include, among others, the Violence Risk Appraisal Guide, referred to as the VRAG, the HCR-20, that is the Historical, Clinical, and Risk 20-item Risk Assessment Scheme, and the Classification of Violence Risk, COVR. These instruments, when scored, can produce a mathematical percentage prediction of violence within a specific period of time. So, for example, a patient could score 67% risk of a violent act within the next 30 days. There's a problem with scoring these instruments, however, and it's that the mathematical calculations may remain the same even though the patient is changing. For instance, if a patient improves over a 7-day inpatient stay, the mathematical score remains the same nonetheless. For example, the patient may still score for a violent act or arrest which occurred within the last 30 days, despite improvement in condition during treatment. Therefore, I recommend that you use these tools as a checklist of items to consider during a structured assessment rather than actually scoring the instrument. Well, that's it for this month. Thanks very much for listening to this ongoing series of risk management tips sponsored by Negley Associates. There's a lot more information available for you on the internet, on our website, and if you have questions, please feel free to call us. For now, though, I'm Ron Zimmett. Thanks for listening.